Welcome to bongosikha. Today I am going to discuss about the citizenship. So first, what is important, that is you have to know what is the meaning and significance of the word or the term citizenship. So firstly, I will discuss the citizenship, that India, like any other modern democratic state, has two kinds of the people, the citizens and the aliens. So the people, those who are full members of the India and are loyal and owe their allegiance আনুগত্য প্রদর্শন করে to the Indian state, they are known as citizens, and naturally they enjoy all the political and the civil rights. On the contrary, মানে অপরদিকে আমরা বলতে পারি যে aliens তারাই, বিদেশিরা তারাই, the aliens are those who are the citizens of some other state, like of some other state, and naturally they are entitled of some other state, and naturally they are not entitled to enjoy all sorts of civil and political rights. Here the aliens again can be classified into two categories, that enemy alliance and the friendly alliance. So friendly alliance, that the people who are from the countries that who are having cordial relation, peaceful relation with India, and the enemy alliance, that the people from those countries who are always in relation with war with India. So obviously the enemy alliance do not the enemy alliance do not is the enemy alliance obviously do not always consider or belong to those countries that they are at. Naturally, the enemy alliance enjoy lesser civil and political rights. What I was discussing, that enemy alliance, that what are the rights enjoyed by the friendly alliance, those rights are not equally enjoyable to the enemy alliance, কারণ তারা শত্রু দেশের অধীনে, তারা মানে তারা সেই দেশের নাগরিক বলে ধরা হচ্ছে। সুতরাং যেরকম এখানে একটা এক্সাম্পল দিতে পারি, দ্য রাইট এগেনস্ট দ্য রাইট টু প্রোটেকশন এগেনস্ট আরবিট্রারি অ্যারেস্ট অ্যান্ড ডিটেনশন, এই আর্টিকেল 22, এটা কিন্তু অ্যানিমি অ্যালিয়েন্সের ক্ষেত্রে এই ফান্ডামেন্টাল রাইটটা কিন্তু প্রযোজ্য নয়। তারা কিন্তু এই রাইটের অধিকার কিন্তু পেতে পারে না, কারণ যেহেতু তারা অ্যানিমি অ্যালিয়েন্সের মধ্যে পড়ে, ক্যাটেগরিতে পড়ে। Next I am going to discuss the Constitution of India confers the following rights to the citizens of India and not to the aliens. Constitution of India কি রাইটস দিচ্ছে টু দ্য সিটিজেন্স অফ ইন্ডিয়া, যেগুলো একজন নাগরিক হিসাবে, ইন্ডিয়ার নাগরিক হিসাবে একজন পাচ্ছে, সেগুলো কিন্তু সমানভাবে প্রযোজ্য নয় যারা অ্যালিয়েন্স ইন্ডিয়াতে আছে, তাদের ক্ষেত্রে কিন্তু সেটা সমানভাবে প্রযোজ্য নয়। এবার সেটা কি, that right against discrimination on grounds of religion, race, caste, place of birth, that is article 15. Then right to equality of opportunity in matter of public employment, article 16. Next, right to freedom of speech, expression, assemble, then reside and settle and to practice any profession, article 19. Right to contest in the elections for the member of the Lok Sabha or the state legislative assemblies, right to hold any public office like the President of India, like the Vice President of India, like the Advocate Generals of the states, the Attorney General of India, judges of the Supreme Court, judges of the High Courts. Then the right to vote as a voter to the election of the Lok Sabha and the state legislative assemblies. So these are the rights which are যেগুলো আমাদের ভারতীয় নাগরিক হিসাবে পেতে পারে, কিন্তু সেগুলো অ্যালিয়েন্স হিসাবে পেতে পারে না। এই ধরনের রাইটসগুলো কিন্তু তাদের ক্ষেত্রে অ্যাপ্লিকেবল নয়, এটা মাথায় রাখতে হবে। And here it is worth mentioning that along with getting these fundamental rights, the citizens also perform some fundamental duties which I have discussed, that to the countries, that like paying taxes, showing respect to the national flag, national anthem, then national and render national service whenever called upon to do so. So constitutional provisions, the constitutional provisions for citizenship are laid down, that constitutional provisions for citizenship are laid down in part 2 from articles 5 to 11. So in this regard, it is worth mentioning that the constitution does not provide any permanent or any detailed, any emphasized provision regarding this citizenship. According to the Constitution of India, it only deals with the how one can acquire the citizenship or the failure of the citizenship. This only it determines. According to the Constitution of India, the persons will be considered as the citizens of India who became the citizen of India as the commencement of the Constitution, that is on January 26, 1950. The Constitution clearly stipulates that the following four categories of people will be considered the citizens of India at its commencement, that is the commencement of the Constitution on 26 January 1915. A person having a domicile in India and has domicile means that is the country that a person treats as their permanent home or lives in and has a substantial connection with, and has to fulfill any of the following three criteria, namely that is if he is born in India, if he's born in India, or his either of his parents is born in India, or he has been a resident of India ordinarily for 5 years immediately before the commencement of the Constitution, can become a citizen of India. Next, that a person can become an Indian citizen if he migrated to India from Pakistan on the condition that he or either of his parents and of his, or of his grandparents were born in undivided India and has fulfilled that any of the two conditions, namely that they have migrated to India on or before July 19th, 1948 and had been ordinarily resident in India since the date of his migration, or if he migrated to India on or after July 19, 1948 and had been a resident registered as a citizen of India. But this is applicable in case for 6 months preceding the date of his application for registration. The preceding the date of his application for 6 months, 6 মাসের জন্য প্রযোজ্য থাকবে যে preceding the date of his application for registration. Next, a person who went to Pakistan but later on he returned to India for reunion or for resettlement can become an Indian citizen. But here also the same thing, same clause, that he had to be resident in India for 6 months, the preceding of his application for registration. Next, a person can be considered as a citizen of India if he or any of his parents or grandparents were born in undivided India, but who is ordinarily residing outside India. So, any person can be considered as a citizen of India if his parents or grandparents were born in undivided India, but he is residing outside India. So that is one case, can become an Indian citizen. On that case, he can appeal to the Consulate General for the his certificate that he will be considered as a citizen of India. Next, there are some constitutional provisions with respect to the citizenship are as follows. If any person voluntarily accepts, মানে স্বেচ্ছাকৃতভাবে সে যদি কোনো অন্য কোনো দেশের নাগরিকত্ব অধিকার করে, কোনো ফরেন স্টেটের সিটিজেনশিপ অফ এনি ফরেন স্টেট উইল নট বি কনসিডার্ড অ্যাজ এ সিটিজেন অফ ইন্ডিয়া। মানে আমাদের ইন্ডিয়ান সিটিজেনশিপ শুধুমাত্র সিঙ্গল সিটিজেনশিপ, মানে অ্যালিজিয়েন্স টু দ্য ইউনিয়ন অনলি। যদিও ফেডারেল পলিটি, যদিও স্টেট দুটো ধরনের গভর্নমেন্ট থাকে, একটা সেন্টার একটা স্টেটে, বাট স্টিল কি ব্যাপারটা হয় যে এখানে যেটা মেন ব্যাপারটা হচ্ছে যে ফেডারেল পলিটি হলো ইন্ডিয়ান কনস্টিটিউশন কিন্তু সবসময় সিঙ্গেল সিটিজেনশিপটাকেই কিন্তু বৈধ স্বীকৃতি দিয়েছে। সুতরাং এক্ষেত্রে যদি একই পার্সন একই টাইমে যদি একটা ফরেন স্টেটেরও সিটিজেনশিপ অ্যাকোয়ার করে, এটা কখনোই সম্ভব নয় যে সে মানে সাইমালটেনিয়াসলি উইল বি আ সিটিজেন অফ এনি ফরেন কান্ট্রি অ্যাজ ওয়েল অ্যাজ দ্য ইন্ডিয়ান স্টেট। And any person, if he is deemed to be a citizen of India, can continue his citizenship subject to the provisions of any law made by the parliament. যদি কোনো পার্সন তার সিটিজেনশিপ ইন্ডিয়ান সিটিজেনশিপ কন্টিনিউ করে থাকে বা মনে করে থাকে যে সে কন্টিনিউ করবে, তাহলে সেক্ষেত্রে যে ধরনের কনস্টিটিউশনাল ভ্যালিডিটি আনা হচ্ছে বাই দ্য পার্লামেন্ট বা যে ধরনের আইন প্রণয়ন করা হচ্ছে সেগুলো তাকে মেনে চলতে হবে। And Parliament is empowered to make any changes regarding the Citizenship Act, regarding the acquisition and termination of the citizenship. Next, Citizenship Act 1955. Citizenship Act the Citizenship Act 1955 stipulates the condition required for the acquisition and the termination of the citizenship after the commencement of the Constitution, that is on January 26, 1950. So the acquisition of the citizenship, the Citizenship Act 1955 clearly stipulates, একদম পরিষ্কারভাবে বলে দিচ্ছে, the acquiring of citizenship acquire করা যায় through 5 ways, namely by birth, by descent, by registration, and by naturalization and incorporation of territory. So one by one now I am going to discuss that. By birth, a person who was born in India on or after the 26th January 1950 but before July 1st 1987 will be a citizen of India irrespective of his parents' nationality. Next, another clause that a person born in India or after the July 1st, 1987 will be considered as a citizen of India if his either parents is a citizen of India during his birth. And apart from this, those who born from December 3rd, 2002 will be considered the citizens of India if both of his parents or one of his parents were citizens of India and the other is not an illegal migrant at the time of his birth. So this is all the clauses under by birth. Next, I am coming to discuss about by descent. So a person born outside India and residing outside India or settling outside India on or after January 26, 1950 and before December 10, 1992 is a citizen of India if his father was a citizen of India at the time of his birth. এই ডেটগুলো কিন্তু মনে রাখা খুব জরুরি যে একজন পার্সন যখন জন্মাচ্ছে আফটার জানুয়ারি 26, 1950 বাট বিফোর ডিসেম্বর 10, 1992 সে কিন্তু মানে তার ফাদারের সিটিজেনশিপের অধিকার সূত্রেই কিন্তু সেও পেয়ে যাচ্ছে যে ইন্ডিয়ার নাগরিকত্ব। And any person born outside India and after December 10, 1992 can be considered as a citizen of India if either of his parents is a citizen of India during his birth time. So then and onwards, December 3rd, 2004, the persons born outside India shall not be considered as the citizens of India unless his birth is registered through the consulate or with the permission of the central government, after the expiry of the above mentioned period and time. So apart from this above mentioned criteria, if a minor who is minor মানে যে এখনো অ্যাডাল্ট হয়নি, মাইনর হু ইজ সিটিজেন অফ ইন্ডিয়া বাই ভার্চু অফ হিজ ডিসেন্ট মানে পিতার সূত্রে যে ইন্ডিয়ার নাগরিকত্ব পেয়েছে বাই ভার্চু অফ হিজ ডিসেন্ট অ্যান্ড অলসো ইজ আ সিটিজেন অফ এনি আদার কান্ট্রি অ্যান্ড অ্যাট দ্য সেম টাইম ইজ অলসো সিটিজেন অফ এনি আদার কান্ট্রি. so will not be considered unless he renounced to the citizenship of that particular country after attaining his full age within the 6 months, within the 6 months after attaining his full age. Next, by registration, the central government can register, মানে আমাদের central government পারে register করতে any person as a citizen of India on an application, provided that he is not an illegal migrant. So if he belongs or fulfills any of the following categories, a person who is a resident of India for 7 years before the making or application of his registration, and any person of Indian origin who is ordinarily a resident of any place outside undivided India, a person who is married to any person who is a citizen of India and is ordinarily a resident of India at least for 7 years before making an application for registration, and minor children of the persons who are citizens of India. They will be also considered by registration as the citizens of India. Then by naturalization, the central government may issue application to the people as the citizens of India on the basis that who is not an illegal migrant, provided that he is not an illegal migrant and satisfies any of the following qualifications or criteria, that he belongs to that particular country where the Indians are not protected or prevented from being the subjects or citizens of that country by naturalization. Next clause, that if he is a citizen of any country where he renounces his citizenship of that country on the event of the application for the citizenship of India, and or in the case he has served in the government of India, or he has resided in India at either or for 12 months immediately preceding the date of the application. Next, by incorporation of territory. In case that if any foreign territory becomes the part of the India, then also the government of India specifies the persons among the people of India, like for example, that Pondicherry when when came under the Indian control, Government of India issued the Citizenship Pondicherry Order 1962. The Pondicherry became the part of India, and under the Citizenship Act 1955. Next, single citizenship. As I told, that single citizenship, that though the Indian constitution accepts a federal polity like USA, Switzerland, that government at the center and government of the states, but in case of citizenship, the constitution only accepts the single citizenship, that is the citizenship to the center and not to the any states. They are unlike other federal states like USA and Switzerland. Next, registration of overseas citizen of India cardholder. The central government may issue an application in this regard, that registration as an overseas cardholder, any person of full age and capacity is a citizen of another country, was a citizen of India after the commencement, but was a citizen of India after the commencement of the constitution. নেক্সট দ্যাট কনফারমেন্ট অফ দ্য রাইটস, কী ধরনের রাইটস এরা পেতে পারে যারা ওভারসিজ সিটিজেন, তারা কী ধরনের রাইটস পেতে পারে, যেটা ইন্ডিয়ার নাগরিক পেতে পারে সেটা তো এরা সেই সুযোগগুলো এনারা পেতে পারেন না। সুতরাং সেক্ষেত্রে কী কী রাইটস আর নট অ্যাপ্লিকেবল, হি শ্যাল নট বি এন্টাইল্ড টু কনফার ভোট, যেটা আমরা ভোট দেই যে ইউনিভার্সাল ফ্র্যাঞ্চাইজ or suffrage. So he shall not be entitled to the right to equality of opportunity in matters of public employment. একটা যেটা আমি বললাম এই মাত্র যে ভোট দেওয়ার অধিকারটা তাদের থাকে না, and the right to equal opportunity in the matter of the public employment, that is article 16 সেইটা, এবং he shall not be eligible for the post of the vice president, for the post of the president, like any dignitary post he shall not be entitled. He shall not be entitled for the contesting election for as the vice president, he shall not be eligible to be considered as the judge of the Supreme Court. He shall not be eligible to be considered as a judge of the High Court. And he shall not be entitled, as I already told, that as a to give his votes to the Lok Sabha elections or the state legislative assembly. So this is all about the citizenship.